Hello, and welcome to the Arbitration Conversation. So in this conversation, we're going to talk about arbitral courts. What are they? Why should we care, right? And what we have is we have an expert. We have Pamela Bookman. She's a professor at Fordham University Law School in New York City. And prior to that, she had been in practice with a law firm there, and she also had clerked for the Court of Appeals, for the International Court of Justice, and none other than the US Supreme Court Ruth Bader Ginsburg, which of course is the coolest thing ever. We could ask her all about that, but instead we're going to talk about one of her recent articles. I had read the article. I think it's genius. It's really interesting, and it's about arbitral courts. So first of all, Pamela, thank you so much for taking time with me.
Thank you so much. I'm thrilled to be here. It's really great to be able to have this conversation.
Yeah, absolutely. So first of all, I guess I want to start with, how did you come up with the idea of studying arbitral courts?
Okay. So arbitral courts is a name that I've put onto a growing phenomenon of courts that try to sort of hybridize arbitration characteristics and court characteristics. And I come at this topic from having originally started practicing and studying transnational dispute resolution, first in US courts. And then the more I learned about transnational dispute resolution in US courts and in courts around the world, the more you realize how much is going on in arbitration. And I began studying the relationship between litigation and arbitration. And there's a lot written about this, the market for dispute resolution, right? The idea that parties get to choose in their contracts where they want disputes arising out of that contract to be duked out, and they might choose courts and they might choose an arbitral tribunal, and there are pros and cons to choosing each one of those different fora. And what's been happening is that different jurisdictions have tried to make themselves more arbitration friendly or more litigation friendly to try to attract that kind of business. So studying this led me to learn about, just in recent years, really the past 10 or 15 years, many different jurisdictions have created their own courts that are focused on international commercial disputes, right? And these are often called international commercial courts. And there's a lot of descriptive work that's been going on saying, hey, wow, look at these, they're really interesting. And some folks, most notably Hiro Aragaki in LA, has said, these are hybrid institutions, and they, whatever the traditional distinctions are between public and private adjudication, they sort of throw caution to the wind and just mix and mash. And I thought that was so fascinating, such an interesting, innovative way of approaching dispute resolution, of approaching the way that you sort of try to make a dispute resolution system that's attractive, that's efficient, that's expert, right? By mixing and matching these different kinds of sort of the traditional attributes of arbitration and litigation. And I found them really fascinating, and I wanted to do a really deep dive into thinking about what they are and what they mean, and whether that sort of, what happens when you throw caution to the wind and mix and match in that kind of way.
Right. Well, and it's a great description. I mean, I'm thinking about the spectrum. We always talk about the spectrum, the different sort of spectrum of dispute resolution processes and dispute system design. But if you were to really sort of nail down what exactly are arbitral courts, I mean, how would you define arbitral courts?
Yes. So the arbitral courts that I study in this paper are courts. They're domestic courts. They're created by a single sovereign, right? By a single jurisdiction. It might be Dubai, it might be Singapore, it might be Delaware, but they're sort of created by a public sovereign. And they're not international courts like the ICJ, the International Court of Justice, or they're not regional courts like the European Court of Justice. But they are courts that are sort of trying to have a lot of arbitration-like, or stereotypically arbitration-like characteristics. So they allow party autonomy over procedure, right? Here's our default procedures, but you can choose other procedures if you want. They permit parties to opt into confidentiality, right? So ordinarily they're public, but if you want to be private, we'll entertain that request, which is one of the aspects I find most interesting. they tend to sort of advertise themselves as exercising jurisdiction based on consent, although it's usually not their exclusive basis for jurisdiction. But if they're going to get international commercial disputes and foreign parties, often those foreign parties are consenting in their contracts to jurisdiction, similar to arbitration. And another interesting thing about them is that they all proceed in English. And almost all of them have adopted a common law tradition. And this is even in jurisdictions that don't speak, right, where English is not the national language or where the jurisdiction is not a common law jurisdiction. They also often employ foreign judges. So the judges are both often not locals, but they also may have experience themselves as arbitrators and or as judges in other jurisdictions. Sometimes they use 3-judge panels as a sort of tip to a hat tip to recognizing the benefits of that. They often offer opportunities for foreign lawyers to appear without local counsel. So another way of sort of internationalizing themselves. And another interesting thing is that sometimes they're willing to enforce parties' selection of non-state law to govern their disputes, right? So this is something that traditionally you don't see in courts, right? Courts say like you have to choose New York law or Delaware law or Singapore law, but you can't choose, some like UNSTRAL laws. But some of these jurisdictions are willing to just be more creative, more flexible, and they very consciously recognize that this is in contrast to arbitration, right? That the thing that they're trying to emulate is like the things you might go to arbitration for, but here in our court.
Yeah, that's interesting. It really is an interesting phenomenon, and I hadn't really thought about it until I was looking at your paper, and I'm like, wow, yeah. Because you also, well, of course, the title, you talk about innovation and limitations of these arbitral courts. What do you mean by that?
So a lot of what I've just talked about, this hybridization, right, is some of the innovation of these courts. And in a way, it's very exciting, right? We who study dispute resolution, we talk about what's efficient and what's sort of beneficial and why you would choose one kind of forum or another. And, the opportunity for parties to mix and match to get what they really want, what they really need, and to, lower the cost and lower the time-consuming nature of some of these dispute resolution processes it's exciting, and it's nice to know that there's still change and experimentation can lead to even more innovation. And I think that they're really another reason I think they're interesting to watch is because we'll see whether it works, right? So I think these are still young. Many of these institutions, they may attract a lot of cases. It remains to be seen whether they will be influential lawmakers. So one of the things I find really interesting about these courts is that because they are technically courts, they can make law, especially because they're often in these common law jurisdictions, even in, say, Dubai, which is not otherwise a common law jurisdiction. And so it'll be interesting to see if these courts, and there are some cases already brewing that are influential in part because there's a dearth of published opinions in some of these areas, in part because the disputes get held in arbitration and the proceedings are confidential.
Right.
But that said, I think that the celebration, I'm a little bit wary of, a total celebration, that this is just sort of the best of both worlds as they're advertised. And they are advertised, by the way. These jurisdictions are like marketing these courts. But also that they have some of the limitations of sort of both worlds, right? Yeah. And, I would admonish these courts and the judges on them to be transparent and not to cater so much to parties to the detriment of the institutional legitimacy of the court, the ability of the court to develop to develop law, right? To develop both their own procedures and their own sort of reputations. And so I think that one of the limitations that I find really interesting is how much judges will give into parties' requests for confidentiality, for example, because if you could have everything with the court, but also keep it all confidential, that that could be attractive to some parties, to a lot of parties.
Oh,
Right. And the power of a court to say, bind third parties, to join third parties, to issue injunctions around the world. There are all these powers that courts have that arbitration usually doesn't on its own. And if you coupled that with confidentiality and sort of catering to the parties before you, that could be I think that could be a dangerous mix.
Yeah, well, and I would think one of the biggest, pieces with the expert decision maker, but there's still limitations, I would imagine, in terms of choosing the decision maker or not.
Well, so it's interesting, so many of so you take something like some of these courts and they have these foreign judges, and the foreign judges themselves are usually like very well respected in their fields. They're brought to the courts in part as a sign of the legitimacy of the court, right? Of this sort of stamp of approval. And of course you can trust this court because of course you can trust these judges, right? This former UK judge. Who's very trustworthy, and I think there's a lot to that, right? There's a lot of like real gravitas to these judges, and I hope that they maintain some transparency about the way in which they exercise that gravitas in guiding the courts in making their decisions.
Yeah,
it's usually not the case that you get to choose your judge. Okay. In these courts. The Singapore International Commercial Court, I believe, will sometimes designate particular judges, not by random, as we would be familiar with in US courts, but if there's two disputes between two foreign nationals and Japanese law is at stake and there's a Japanese foreign judge, they might assign the Japanese judge because of the expertise in that particular area. So there's some specialization, but it's not the judge picking. That's a big difference. Is usually not by the party's choice. Although it could be, right? They could change that.
Yeah, I would wonder. I mean, when you talk about limitations and innovations, you kind of wonder about that. The other piece, you talk about obviously confidentiality, but also procedures, right? So kind of creating your own, maybe easing some of the more strict traditional procedures in the name of efficiency. Could be something very attractive to parties.
Yeah, I would think so. And a lot of these courts sort of advertise how quickly their turnaround is.
Yeah, right? I would imagine. Absolutely. Well, this has been a great conversation and a really interesting article. I welcome those to look for it. They can find it on SSRN. Pamela Bookman, thank you so much for taking time. This is really interesting and you're doing really great work. So keep it up.
Thank you so much.